appeal in the matter of Dwyer and Fredbar and another party.
Yes, Mr. Court.
Good morning, my lord. Before I resume my submissions, may I simply deal with the authorities handed up on my learned friend this morning?
Yeah.
All members of the court should have received copies of Panayiotou and Quantum. As I understand, it's for my learned friend in reply to address you on it. That Panayiotou has been provided to the court because it's really the basis for some of what Lady Justice Carr says in Quantum.
Yeah.
I say no more about it. So, if convenient, may I resume where I left off yesterday? I dealt with legitimate interest and equality of bargaining power, and the next subheading is categorization or classification. And the court already has the point that it's not simply a question of either of those, no matter the context of the particular case. But the reality is that the focus on equality of bargaining power has led to a distinction, certainly historically, between the vendor-purchaser cases on the one hand and the master-servant cases on the other. The question is, what happens in a case that is betwixt and between the two? And the court has seen a number of the cases, certainly some of the older cases, which deal with the question of classification. I'm not going to go over those, but I'll take the court, if I may, to three cases which I don't think you have seen so far, which deal with this issue. And the first place to start, they're all in the authorities bundle, is tab 8. Page 2112, or 212 even. Court Appeal case from 1976, Office Overload and Gun. Lord Denning, Lord Justice Lawton, Lord Justice Bridge. This was a licensee case, which has some analogy with franchises. And if one looks at the head note, that asks the court to read that themselves just before the held allowing appeal, you will see the essence of the business involved there.
Yeah.
And we pick up, it's at page 214 of the bundle, the report, page 41. It's by the second punch hole. We can see 5 lines to the bottom. In master and servant cases, the court will not restrain a servant from competing, but in a vendor and purchaser case, it will restrain the vendor from competing. This case is somewhat betwixt and between.
Yeah.
Now, as I said, most of the other cases, including Bridge and Deacon, we dealt with yesterday, I'm not going to go over. So we can fast forward to tab 23 of the bundle, which is Ideal Standard International. It's an employment and shareholders agreement case. Decision of Sir Ross Cranston sitting as a judge of the High Court.
Yeah.
Can you give me the tab number again?
I do apologise, my lady. Tab 23, it's a bundle,
Got it.
page 599. I'm going to take you directly and solely to the sidebar,
28.
indeed, because that summarises the cases which the judge rehearses above. If I can ask the court to read paragraph 28 to yourselves.
That sort of demonstrates the point, really, doesn't it? Because what he's got in mind in that last bit is the type of sale of shares that involves an employee with who's part of an incentive scheme.
Exactly.
And he's really saying, well, that is closer to employer-employee cases.
Indeed. So he established, first of all, that there's a spectrum.
Yeah.
It's not simply as a bifurcated position.
Yeah.
And secondly, again, stresses the importance of clauses being negotiated.
Yeah.
Now that passage subsequently been cited in at least 2 other cases in the bundle.
Yeah.
First is guest services worldwide,
Yeah.
which we were taken to yesterday, but we didn't get this far in the judgment. It's tab 25, bundle page 634 is where it begins. If we can go directly to penultimate page, page 647.
Yeah.
You will recall my learned friend took you through paragraphs 41.
Yeah.
He didn't, I make no Christmas this whatsoever, take you to paragraph 42, which simply sets out the paragraph of apparent approval. I've just taken you to from ideal standard itself.
Yeah.
And the most recent consideration of this point is in one of the 2 cases which included within the bundle which post-date the respective skeleton arguments. It's tab 27,
Yeah.
case of Law by Design Limited and Ali, decision of Jason being a QC sitting as a deputy judge of the High Court. It's quite a comprehensive review of the authorities
Yeah.
from bundle page 674 onwards.
Yeah.
We've highlighted passage.
Okay.
But it's paragraph 59, so in fact let's just take it in stages. Paragraph 58, the classic distinction between the 2 kinds of cases. 59, difficulty is something which has aspects pertaining to both of those 2 classic circumstances. And the judge highlights the fact that the courts have resisted the rather blunt approach of seeking directly to categorise the relevant transaction. Instead, the question is one of substance, not of form.
In case it helps, I refuse permission to appeal this judgment last
Beg
week.
your pardon?
I refuse permission to appeal this judgment last week. So this is the final word, at least in.
Well, I wasn't aware of that and I should have been. Thank you very much
Subject to
indeed.
an application under 5230.
Subject to an application under whatever it is.
And we can. Paragraph 60, there's principles summarised in Cavendish Square by Mr Justice Burton. Again, talking about more freedom of contract between buyer and seller than between master and servant.
But it's worth picking up as well what he says in Little Roman 8. The court should be
Yes.
slow to strike down clauses freely negotiated between parties of equal bargaining power.
Yes,
So once again, that point appears.
yes, exactly. And then I was going to take you then to paragraph 61, cites the victim of Cranston, which we've just looked at.
Yeah.
So I say the simple point of all of this is that it's not a mere case of categorization. One has to look at the substance of the matter. And within any one context, there can be features of the case which tend more towards one outcome than the other. And by way of proof of that, even if one looks within the category of employment cases, it's quite apparent the importance placed to the particular role that the individual in question had. And we've seen some of that already yesterday. Guildford, that was the managing director, highly responsible and confidential position. M&S Drapers, the collector salesman on £10 per week, led to the distinction in the subsequent case, well, a managing director can look after himself, a traveller cannot. A lot of the other cases, for obvious reasons, not least ability to fund this to bring to court, people with very senior positions. The partner in the firm in Bridge and Deacons, Weisinger and Weisinger, the highly successful salesman of financial services. Hanover Insurance Brokers, a case you haven't seen, it's tab 39. Again, a chairman and managing director.
Yeah.
On we go, Dawny Day, the experienced brokers of European bonds. So even within the employment sphere, there are cases at one end of the spectrum and cases at the other. One other point of distinction between the master and servant cases on the one hand and the sale of business cases in the other is that in the latter, so the sale of business cases, covenants are entered into at the covenanter's point of exit from the trade or business, as opposed to the point of entrance. And this is a point of distinction where franchise cases and employment cases are alike. They're made when the franchisee, when the employee joins the business in the broadest sense, while these vendor purchaser cases are where the person who has built up the goodwill sells that. It is part of the consideration, and the vendor is the covenantor, in distinction to the position in franchise cases. Now, this is part a question of timing, but really it's a question of concept. And as Lord Macnaghten observed in Nordenfelt, you may not sell the cow and sup the milk. And for your note, the page reference is tab 1, page 41 of the bundle. I'm not proposing to take you to it.
Yeah.
But that, in my submission, is a significant distinction between the franchise case at the covenantor is entering into the covenants at the point of entering the business. And one can well see why it's pernicious for a vendor who sells the goodwill business, and as part of the price for that is the undertaking not to compete, then to about turn and to do exactly that which he said he would.
Well, hence all the references to not derogating from grant.
Indeed,
And,
yes.
and equally the references to parties being on equal bargaining terms, because if you're selling your business, by definition, you're in control, if I can put it that way.
Yes.
I mean, it might be said, and I think it is said by Mr. Jones, that your client chose to become a franchisee, but it's a different form of choice, if I can put it that way.
Yes. Indeed.
The public policy is different as well, isn't it, at that stage? Because if you're selling your business, there's a very different public policy analysis to the restrictions that should be in place afterwards than if you are an employee and you would say, I suppose, a franchisee.
Yes. Yes. And in a case like Aled Bar and Weisinger, there was a practice buyout, and in some of these cases, significant sums were paid across. Now, true it is that adequacy of consideration is not per se a consideration, but nonetheless, one can have regard to the commercial reality of the situation, which is a function, the point my Lord the Chancellor just made, namely the commercial bargaining power of the two parties.
Is that how you'd reconcile Allied Dunbar? Because Allied Dunbar is a case that tends to step back from the idea that you look at reasonableness. I think that's the Millett case, isn't it, where he talks about proportionality not being the test. But Allied Dunbar as a case is a share sale case, so it's at that end of the spectrum where you're not worried about.
Yes, I said it's what one might call an exit case. The individual is the practice buyout. It's successful self-employed salesman, and I think some involve £386,000, whatever it was, but nonetheless it's a significant sum paid, and part of that price is the undertaking not to compete. And in the passage in Cavendish, which we just looked at, set out in law by design against Ali, the proposition that it is in the public interest that the seller should be able to achieve a high price for what he has to sell, which is my lady's point. I now move on to make 6 propositions about the franchise cases. There are a number of them in the bundle. My learned friend took you to all but one of them yesterday. To say there are 6 important points to draw from them. First of all but one are first instance cases, and of those 2 are interim injunction cases, Call Quick and Dynarod. True it is that Dynarod, the test adopted by Mr. Justice Neuberger, was that he said the case came within the exception to American Sign Limit, so one could have regard to the merits. But nonetheless, the question before the court in those two cases was whether to grant an interim injunction.
Well, it's true that they're all first instance cases bar one, but the real question for us is whether they're rightly decided, isn't it? If they're
Yes.
rightly decided, it doesn't really matter.
Secondly, the pronouncement in those cases that the franchise is closer to sale of business cases than master and servant cases. It partly ignores the warning on categorization that appears in the other cases. Sometimes is qualified. Dynarod, Mr. Justice Neuberger said that the case there didn't fall happily within either of the two categories. And significantly, each of the cases, that assertion that they are closer to one side of the line than the other is made without any real analysis of the equality of the bargaining power in play. Third point is that the franchise cases, one sees remarkably far fewer authorities cited and relied upon, and much less consideration of public policy and the extent to which, if any, the covenant required the covenantor to start afresh.
Sorry, just repeat that last point, Mr.
Yes.
Garland.
So the far fewer authorities cited, that's the first bit of it. And secondly, there's much less consideration of public policy in the extent to which, if at all, the covenant, if enforceable, required the covenantor to start afresh, which is the language used in some of the employment cases. If the employee is prevented from using his lawfully acquired skill and prevented from being employed in that industry, in that sector, then by definition he or she needs to start afresh. That is not a consideration which the courts have considered in the franchise cases. The next point is that all the franchise cases are ones where the franchise agreement was well established. And I'm going to give you the approximate length of operation of each of the franchise agreements and the reference to them. The Call Quick, the agreement had been in operation for about 12 years. It's tab 14, page 285.
Sorry, can you be a little clearer for my benefit as to what you mean by the agreement? Are you talking about the generality of the franchise operation or the specific agreement with which the court was concerned?
The latter. So it's not even the duration of the term entered into, it's the duration of the agreement as at the point of trial.
Right. So inherently, therefore, cases in which one would expect there to have been a substantial degree of goodwill built up during the course of the agreement.
Indeed. Yes, and that's the point I'm getting to. So Call Quick, 12 years. The agreement had been in existence for 12 years, approximately by the time of the hearing. Reference to that is tab 14, bundle, page 285.
Yeah.
Dynarod, approximately 9 years. Tab 17, page 355. Next case, Chips Away, 5 years. Tab 18, page 367. And finally, the cases to which you've been taken already, Care Watch, tab 19, page 377. That was nearly 14 years. And the one case you haven't been taken to yet, but I shall do in due course, is Countrywide Signs. That's at tab 26, bundle page 649, approximately 5 years. So developing my Lord Justice Arnold's point, in all those cases, the franchise was more developed. Definitions, greater goodwill. And that leads to the next point, that in those cases, there was little consideration of the existing goodwill when the franchisee bought into the franchise, and little consideration of how the clause supports the freedom to contract over the freedom to trade. Sixth point is that Chips Away, which is the Court of Appeal Authority, is not a case on enforceability at all. It's a case purely on construction. Sir Andrew Park, at first instance, only considered the question of construction, and the Court of Appeal, there was a respondent's notice dealing with the enforceability, but that was withdrawn. If we turn tab 18 to page 368, the beginning of Lord Justice Dyson's judgment,
Yeah.
paragraph 1, the encapsulation of the issue of first instance. Paragraph 2, judge did not go on to decide whether it was contended by the defendant covenants were enforceable. Paragraph 3, in this appeal, the claimant says the judge misinterpreted the relevant restrictive covenant and should have held the defendant had acted in breach. There is a respondent's notice by which the defendant says that if he acts in breach of the agreement, the covenant, it was unenforceable as being an unreasonable restraint of trade and country to public policy. But the defendant has not pursued his respondent's notice. That's the critical bit. It follows that the single point that arises on this appeal is as to the true meaning of the relevant restrictive covenant. Now, what was said below, and there's some echo of it in the appellant's appeal, is that Chips Away was a conclusive answer to some of the points I was raising at first instance. In great respect, it can't be, because it's simply a question of construction. And we know from long-standing authority, and the classic source for this is Apston and Seddon, that the courts will deplore the citation or reference to clauses in other cases in support of the construction of the clause before the court. You don't have Apston and Seddon in the bundle, but it was cited in my closing submissions. I can give the court the bundle reference number. It's supplementary bundle, tab 16.
It's a familiar principle.
Exactly, my lord. It's partly why we haven't put it in here, but if you wanted to go to it, it is extremely well known. It's the classic authority. Tab 16, page 241.
Page
241, my lord.
Okay.
I'm going to turn to the question of territorial scope. A number of the cases show a disinclination on the part of...
Just before you get on to territorial scope, a thought is prompted by that last observation of yours. And as I say, it's a familiar principle. But on the other hand, also a familiar principle is the idea that courts should strive for consistency. And that's particularly material in this context, where, of course, one has to bear in mind that the cases that come to court are a fraction of those where disputes arise, and cases that get to this level are an even smaller fraction. And where you've got cases saying, well, 12 months is reasonable, and there's a pattern of case law to that effect. Obviously, one has to be cautious because it always depends on the facts and circumstances of the individual case, and there can never be any rule to the effect that just because 12 months has been held reasonable in one case, well, therefore it follows that that's always going to be reasonable. That would be absurd, obviously. Mm. But what do you say to the proposition that the courts should be striving for consistency and treating like cases alike so far as they can, particularly when it comes to the question of duration of restraints?
Well, dealing with that, my lord, in stages, first of all, as your lordship has acknowledged, every case is different. Every case needs to be looked on its facts. Of course, parties will inevitably cite cases they perceive to be similar to their position and on the other side as very distinct. And the real question is to what extent that comparison is a valid one. That goes back to the individual specifics of the case. It may well help to say, well, actually, it's a general presumption that a restriction of this length of time is good in one context, is good in that context. But while one can even have guidelines, it's very difficult to have an absolute rule. So I certainly agree, respectively, with the proposition the court should strive for consistency, but that must not overrule the abiding obligation of the court, which is to determine each case on its merits and on the material before the court.
Thank you.
Unless there's anything arising out of that, if I turn to territorial scope, I was about to begin proposition that courts have shown a disinclination to enforce covenants which go beyond the territory in which the individual, here a franchisee, was operating. And one can see that from a number of cases. Perhaps the best place to go to is Colquick. That's tab 14 of the bundle. And it's at page 294. The judge refers to the Court of Appeal in Office Angels and Rayner Thomas and Connor. This is towards the top of bundle, page 294. Report, page 123. And there's a lengthy extract from the judgment of Sir Christopher Slade, as he had by then become, in that case.
Yeah.
Now, that elegant phrase, the functional or functioning correspondence, it varies slightly between the subsequent cases, has been picked up in other cases, including Dinah, Rod and Reeve, where Justice Newberger describes Sir Christopher Slade as Lord Justice Slade. That's clearly, and it doesn't identify Office Angel, but it's clearly the authority to which he's referring. Other cases as well. Point of this, of course, when we get onto it, one of the clauses, substantial buffer clause in this case, seeks to prevent the defendants from trading out with the exclusive marketing territory. I say that has generally been disapproved in the cases. Lest there be any doubt, I don't say that that is an absolute rule. It can't be. It needs to depend upon the specifics of any one case. But it is a proposition which has been observed, and then one needs to look at any attempts to restrict someone from beyond the territory, further beyond the territory, with particular care.
Yeah.
I was about to turn to the question of the burden of proof, which I can deal with very briefly, although it is important in this case, but perhaps I can deal a slightly different point first, which is that one of the issues debated yesterday was the appearance of written consent provisions in a restrictive covenant. My learned friend made the point that no case for which he was aware has the enforceability of a clause fallen because of the absence of a written consent provision. There are, I think, 6 cases in the authorities bundle in which there is effectively a written consent. And they straddle the entertainment cases, the franchise cases, the one employment case, and one business vendor-purchaser case. perhaps I can take the court to them now. First case is Schroeder and Macaulay. I acknowledge at the outset that is rather different, as we shall see from the wording. It's worth going to in any event. It's tab 7 of the authorities bundle. Bundle page 206. Lord Reed's speech. So internal report 1312 by letter E.
Without the publisher's prior written consent.
Yes, as I said, that's slightly different from the other cases. I don't rest my submission.
That was the assignment provision.
The next case is Watson and Prager. That's tab 12. Tab 12, and then page 266.
Without obtaining the prior written consent of the
Yes.
manager.
Indeed.
Where's that?
It's letter D.
4, obligations of boxer. The end of Roman 1.
Does my lady have
Sorry,
that?
I've got it. Thanks very much.
Okay. Next case, if I may move on, is tab 18, Chips Away. Page 370. At the bottom of the page, below the second punch hole, clause 23 is headed restrictions after termination, and it's A, without Chips Away prior written consent.
Well, that's bang on the point, isn't it? Because it might be said of the previous two cases that
They are different.
it was in the clause, but
Yes.
it was a bit of the clause that wasn't dealing with post-termination
Yes, indeed.
restrictions.
Indeed.
But here is a provision
Indeed.
directly referable to restraint of trade.
And Care Watch, which is the next case, the court's content for me to move on. Tab 19,
Yeah.
page 398. Paragraph 75, between the two punch holes, 8.2.7.1. Same point, my lord.
Yeah.
And what's interesting is that it appears that the court, Justice Henderson, who then had regard to that,
Yeah.
one looks at the judgment, paragraph 139. So that's bundle page 419. It's really halfway down the passage,
Paragraph 139.
139. Some 10 or 11 lines down, sentence begins halfway along. If it turns out that this prohibition gives rise to operational difficulties for focus, I simply invite the court to read on. And that's context for the last 7 lines, which contains the reference, 5-6 lines from the bottom, save with the prior written consent of Care Watch.
Yeah.
So it appears from that was one of the matters to which the judge had regard. An ultimate case is Egan Zender, that's tab 24. Employment case, bundle page 610. Top of the page. Paragraph 7. One can see the restraints set out there, quotations. I do apologise. Bundle page 610. So it's internal report, page 161, paragraph 7 at the top. The other four restraints from Claimant clause 13.2.
Yeah.
And the final case is Harker Sinclair. That's obviously, I don't have, for obvious reasons, don't have a bundle reference for that. We'll navigate within the internal report. It's page 2. I don't know, I've lost the reference, I need to find it.
Well, I think a paragraph reference is going to be most convenient.
Yes, exactly. Can you bear with me for a moment? I'll give that to you later
Yeah,
on.
it's paragraph 13 of the
I'm
judgment.
grateful.
Subparagraph 2 undertakes not
Yes.
to use the confidential information without first obtaining a written agreement.
Yeah, exactly. The court's content to move on. Turn now to burden of proof.
Yeah.
Should be clear and common ground that the burden is on the covenantee to prove the reasonableness and that the clause in question goes no further than to provide adequate protection. It's also for the covenantee to call evidence in support of its case. That's a rather self-evident proposition, but can I invite the court to turn?
Well, can I ask you what
Certainly.
you mean by that? Because clearly there's a burden on the covenantee to adduce evidence to establish that he has an interest which merits protection.
Yeah.
But are you saying that the covenantee is obliged to produce evidence on the question of reasonableness? Because surely that's a matter for judicial assessment.
Your Lordship's quite right to pick me up on that. I mean, needs to provide evidence as to the legitimate interest which it's seeking to protect.
Yes.
But also, although the question of reasonableness is for the court, nonetheless the covenantee will be well advised to provide evidence to show as to why it contends the clause in question goes no further than is reasonably required.
Surely that's a matter for argument and submission.
Well, but it requires material on the basis of which to make those submissions. One can't. And
I don't quite understand that. Of course, if there are relevant factual circumstances that are being relied upon by either side, the party relying upon those factual circumstances must produce evidence to prove the facts. But when it comes to the question of reasonableness, why is that not a matter for submission?
well, we may be at odds. It's a distinction without a difference. But can I take the court to countries-wide signs to hopefully make good my point? So that's tab 26, the bundle.
Yeah.
This is a recent decision of Stuart Isaacs, QC, sitting as Deputy Judge, High Court. Franchise case.
Right.
You haven't seen this before. Let's take it in terms, page 651, paragraph 14. One can see the matters in issue. We're only concerned with the second issue, the unenforceability of the restrictive covenants. And I'm setting the scene and ask the court to turn on to page bundle 653. And invite the court to read paragraphs 24 and 25 in particular.
So there's just reference in 24 to compilation of information. So that seems to be focusing upon confidential information.
Yes, that's the inference in there.
It certainly doesn't seem to refer anywhere to goodwill, does it?
No, but I say it stands for a wider point, which is that the covenantee needs to produce evidence.
But is what he says right? I mean, insofar as he's envisaging some need for the claimant to produce evidence on the issue of reasonableness, what evidence can he have been envisaging?
But this, in a sense, it isn't evidence of reasonableness, is it? I mean, what he's focusing on here is evidence as to why a 12-month period of restriction was necessary because of the need because of the length of time that we required to train up, as it were, a new franchisee. And he's making the point that that evidence wasn't, it was difficult to see how it could possibly take that long.
As well as saying, if one looks at the end of paragraph 24,
Yeah.
as counsel was unable to point me to any evidence which supported the reasonable need for a 12-month period. Claim submission came down as to be inferred from the nature of the claimant's franchise business that such a period was reasonably necessary. So the point I'm striving to make here is that one needs to adduce evidence. One simply can't point to previous cases to say, well, a year was reasonable in this case, a year was allowed in that. One can generally infer the goodwill of a franchise is such that it's going to take a year to find another franchisee. These are matters in relation to which there needs to be evidence.
I'm grateful for your clarification, and I accept what my lord says, but I'm still a bit puzzled, because if one focuses then on the points that's being made, the judge is really addressing the submission made in reply. Compilation information not all required. 12-month period was needed in order to find and train a new franchisee, get the new franchise up and running. And what the judge says is, well, there's no evidence to support that. So I understand that so far as it goes, but that seems to completely disregard the factor that Mr. Jones relies upon in the present case, which is not the length of time that the new franchisee needs to get trained and so forth. It's the need for the new franchisee to get a clear run.
Yeah.
What do you say to that?
Well, the way the evidence in this case was that it was 12 months with the time it would take to find a new franchisee. That was the evidence given by Mr. Jean, paragraph 47 of his third witness statement.
We'll have a look at that.
Yes. That's the supplementary bundle.
Yeah.
Tab 11. Bundle pages 100 to 101.
Yeah.
It's certainly worth the court's while to read this paragraph in total, because it then provides the context for a paragraph in the judgment which you haven't been shown yet, and I'm going to take you to shortly.
Which paragraphs do you want us to read off?
Just 47, my lady.
47, thank you.
I'm grateful to you for drawing that to our attention, but I'm still a bit puzzled, because that is making the point about the need for a clear run.
Yeah.
Is it not?
Well, there is an element of that, but in my submission, the focus is the time to find another franchisee. top of bundle, page 101.
Well, the difficulty with that submission is that the point he's making is that it's difficult to recruit another franchisee if, in fact, the previous franchisee is still, as it were, trampling all over the territory. I mean, that's expressly what he says. Makes recruitment of new franchisee for the area difficult. Significantly prejudices the future success of the new franchisee, as customers of the previous franchisee will frequently be retained. So I'm not sure that it is really a focus on how long it takes to get a new franchisee as such, as opposed to the need for a new franchisee to have a clear run. Anyway, we've got the point. Okay.
So that concludes my summary of the legal propositions. I now turn to the grounds of appeal.
Yeah.
And invite the court to look at the judgment. Again, we've seen most of the relevant parts.
Yeah.
But can I invite the court to turn those looking within the bundle, it's core bundle, tab 5, page 88. Paragraph 294, for my Lord the Chancellor, reading a different copy, 294. We see the judge's assessment of the evidence which I've just taken this court.
Yeah.
So, I'm going to adopt the approach taken by my learned friend and deal with the reasons A to K in the groupings which my learned friend did. So dealing first of all with grounds A, B, C, D, what the appellants call the risk of failure and sympathy for the covenantor. The first point to make is that the word sympathy does not appear in the judgment. It's the claimant or the appellant's creation. And it's at odds with other parts of the judgment. Not least paragraph 307, which I don't think you've seen yet. Page 91. Second, third lines, differences in scale do not mean that dominant parties should not be entitled to enforce its contractual rights. The judge well had in mind the need and the importance for commercial parties to uphold their rights. What he is doing in 305A to D is identifying the inequality of bargaining power. Mr Bartlett's inexperience and the absence of any negotiation in the terms of the agreement, and the prospect of, and indeed consequence of failure. All of those, I say, are relevant factors having regard to the legal framework I have shown to this court. They're factually correct, and there's no challenge to the factual finding, merely the relevancy of those points. In terms of consequences, if the covenants were enforceable, the defendants, I treat them compendiously, would be unable to work in at least the exclusive marketing territory for 1 year, irrespective of the limited impact of the competition. This is whether as a franchisee of another franchise, as an employee for a company with no ability to bring in work, as the example given by my Lord Justice Arnoild yesterday, or indeed as he sought out to do as one man in a van. Ultimately, the covenants, if enforceable, would prevent Mr Bartlett from using the skill, knowledge and experience which he's lawfully acquired, which is not the claimant's property, but is his, and has restricted his ability to work as a plumber. Effectively, he's limited to undertaking emergency services, or plumbing services, certainly out with the territory, and if the substantial buffer clause is enforceable, out with that ring as well. This is why the tendency to lump franchise cases with vendor purchaser cases rather than employee cases can fall down on certain circumstances where the reality of the covenant is to prevent an individual from earning his or her wage. Turn now, if I may, to subparagraph 305E, described as the sliding scale reason. There are two aspects here. One is the written consent, and the other is the sliding scale itself, having an increasing duration the longer the franchise agreement has been in operation. Now, I would assume it's quite possible, indeed happens in practice, to have a written consent provision in restrictive covenants in all areas. We haven't even begun to look at the real property arena where they are invariable. Turning to the second point, the sliding scale, what was said in the skeleton argument is that the judge has tried to work back from the position and has had regard to matters which postdated the agreement. With respect, that mischaracterises what the judge held, clearly accepted the agreed position that the test of reasonableness is to be assessed at the time at which the contract was made. That is apparent from the words of 305E itself, by identifying the likely position that at the end of the 10-year term, the goodwill to predicted would probably be substantially more valuable. There's nothing in that which suggests that the judge considered matters with the benefit of hindsight. And there's nothing unprincipled or unworkable in a sliding scale of restriction increasing over the length of a 10-year term. Such a device would reflect both the duration, would reflect the duration of that term and the journey that a franchisee could well make during that process, starting off as here as an assetless novice, and at the end potentially being charged a number of vans and having a very considerable business. In employment cases, as an individual goes up the employment ladder, he or she would get a new contract with invariably increasing covenants. Doesn't matter whatever context one takes. So in the financial services industry, a barrister's clerk, the same proposition holds true. What would be reasonable for a junior clerk is clearly not reasonable for a senior clerk. By contrast, here we have a one-size-fits-all for a franchise entered into for a 10-year term. And to say that having a sliding scale would be difficult to draft ignores the complexity in the terms of the franchise agreement itself. I took you yesterday to the definition of the management service fee, Schedule 1 to the agreement. I can take you there again, but you will recall the detail of those provisions and the fact that there are three variable terms in play. The territory.
It goes up over time.
Beg your pardon?
It goes up over time.
That's one of them, my lord. It goes up with the greater the territory, and it goes up the greater over the turnover. One has three variables in play. If that is possible for the management service fee, why not for the restrictive covenant? And my learned friend said yesterday, in answer to both these parts of 305E, that there's been no case in which A clause has been found to be unreasonable for want of a written consent provision, or B, there's been no case where there's been a sliding scale. And in answer to that, I would say this. What is the argument on the other side? Only this, that no case has been found in which it has been done before. That argument does not appeal to me in the least. If we never do anything which has not been done before, we shall never get anywhere. Those well-known words of Lord Justice Denning in 1954 apply with equal force nearly 70 years on. Moving to subparagraphs F, G and J.
Well, it might also be said that the other franchise cases didn't need to consider whether such a provision would be reasonable, because they were all cases where the franchise was well established, as you've shown us, for a number of years.
Exactly, completely different cases.
So if you've had the franchise for 5 years, it's going to be difficult to say, well, I should have had a contract with a sliding scale in it.
I suppose the answer to that might be that, strictly speaking, that's irrelevant, because you have to consider it the date you enter into the agreement. But it inevitably colours everybody's attitude.
Indeed.
Yeah.
Exactly the same way that the management service fee is structured. That's predictions as to what's going to happen in the future to certain collars.
Yeah.
It doesn't know whether those are going to be bettered or not bettered, but that's simply part and parcel of the process. Now, I made oral submissions in closing before the trial judge to the effect that a sliding scale would be appropriate, and that towards the very end of the 10-year term, it may well be that a period in excess of 1 year was appropriate for someone who's built up a flourishing franchise, perhaps getting towards the end of the term, indicated not going to renew it. It may well be that a period in excess of 12 months would be reasonable. Turning then, if I may, to subparagraphs F, G and J. This is really the width of the provision. It's easiest to take J first because we can dispose of it. This is the trade secrets point. Now, common ground, there were no trade secrets to be protected. In terms of F, we've already covered a large part of this already, was that the covenant prevents the defendants from operating as plumbers in any way, whether as self-employed, franchisee, one man in a van, you name it. Simply covers everything. And there is no escape clause, there is no caveat, save for the financial interest, which I'll come on to when we get to the blue penciling. There was no evidence in this case of real loyalty on the behalf of customers in the way there might be in relation to a hairdresser, as a classic example where the point of loyalty is often made, someone attending a McDonald's restaurant or whatever. Again, to repeat, this was primarily emergency services where someone's willingness to choose X over Y is likely to be a matter of happenstance and who is available at the time. As a consequence of that, the defendants had no real special connection with clients, save for national account clients, provided for, if they were provided for, by the claimant. Within this concept of the width of the extent of the provisions, it's also helpful, perhaps appropriate, to raise respondent's notice ground 3, which is that there is no legitimate interest in simply reducing competition. Now, I've taken that as a respondent's notice point out of an abundance of caution. In my submission, it's really covered by F and G in any event. We've seen the authorities, office this morning, the decision of Lord Denning was one, which says that employees will not be restrained simply from mere competition. And I say that this is the effect of the covenant here. Prevents the defendants from competing, mere competition to any extent. Some trades or businesses, the skills acquired in one sector may be transferable to another. So a courier, someone involved in logistics dealing with, I don't know, furniture delivery, it's the customers they're familiar with. That may well be the franchisor or the employer's business and property, but the driving, the sort of mechanics of the business, that is a transferable skill. Here, the defendants were involved in plumbing. Mr Bartlett personally was doing the plumbing. He'd hired a van and invested in other equipment for that. That is not transferable. He has to be involved in plumbing, and the only way permitted by this, according to the covenant, is to do it outside at least the territory, if not the buffer. And paragraph F, really, this point was raised by my Lord Justice Arnoild yesterday, and I've dealt with it again this morning. I don't need to repeat that. The various ways in which the defendants would be prevented from going about their business. I turn now to subparagraphs H and I, which is the unreasonable radius point taken by my learned friend. This concerns the other part of the covenant, seeking to prevent the defendants from being engaged, concerned, or interested in a business similar to or competitive with the drain doctor business, which operates within a radius of 5 miles from the exclusive marketing territory. Now, the claimant's case was that that was a small peripheral ring. As I've said, the defendant's position is borne out by the map I showed the court yesterday, is that it's a substantial buffer. That's beyond the exclusive marketing territory. There is no functional correspondence, to use Sir Christopher Slade's phrase. In my submission, seeking to prevent people from working within that buffer is entirely unreasonable and unprincipled. And finally, point K, this is the reciprocity point. So my learned friend said yesterday he doesn't understand that paragraph. As I said yesterday, what it is not dealing with is the general bill posting point. That is quite clear. Talking about reciprocity is an odd way with respect to describe the situation that if there has been fundamental breach accepted, the covenants fall away. What the judge is, or the point the judge was making here was different. If the agreement were terminated by reason of the claimant's repudiatory breach, for example,
if it were terminated by
reason of the claimant's repudiatory breach, so a variation on the facts of this case, if there had been no affirmation by my clients, there would be nothing preventing the claimant from appointing another franchisee to the exclusive marketing territory with an immediate effect, who would be in competition with the defendant's right to operate in that territory, unrestricted by any covenant in relation to them. I say that the point the judge is making is that quite simply parity or reciprocity would require that the claimant could not seek to operate in the exclusive marketing territory for the requisite period in those circumstances. Yeah. And we've seen the significance which the Privy Council and Bridge and Deacons played to the mutuality of the covenants. All the partners signed up to them, whether junior or senior. Here, there is no quid pro quo. We are very nearly done, my lord. The last two grounds, one is a ground of appeal, one is a respondent's notice of appointment, they both concern blue penciling.
Yeah.
And I say that quite simply, the ability to sever does not apply here for a number of reasons. First of all, this is a point where the parties are in agreement, the two covenants, one dealing with the EMT, the other dealing with the buffer, are self-standing covenants. So if the court were to find, as I suggest is clearly the case, that the buffer is quite clearly unreasonable, that covenant falls, but has no effect on the covenant relating to the exclusive marketing territory itself. So that doesn't help me. But the criticism made of paragraph 306 in the judgment, where the judge says this is not a case where the unreasonable part can be severed, the criticism made by the appellants is that, well, that's unexplained. In my submission, it's abundantly clear why it couldn't be severed, because there is nothing one can do to remove the offending parts, but keep something there. It seeks to prevent the franchisee, as we said, from being engaged, concerned, or interested in a business similar to or competitive with the drain doctor business for 12 months. Exercising any one or two of engaged, concerned, or interested has no impact on the application of the covenant to the defendants. Exercising similar to, this may have been one of the points my Lord Justice Arnoild was referring to yesterday, I say that is unreasonable, but that doesn't help me because competitive would still stand. But if one excises both similar or competitive to, there is nothing left. The period of the covenant is 12 months. That's either reasonable or it's not. There is no way of saving this covenant by reference to severance. One of the ways the appellants seek to make good their proposition is by referring to the possibility that the defendants might have a non-dominant financial interest. But that's expressly provided for in the parenthesis of the covenant itself. So simply not a question of blue penciling at all. It's already provided for. Blue penciling doesn't arise. And the last point is ground 2 of the respondent's notice, which in my submission is an additional point not dealt with by the judge as to why the covenants are unreasonable and why the objectionable part cannot be severed. I say that on a proper construction, the words being engaged, concerned, or interested in a business similar to or competitive includes having an office or a business base within the exclusive marketing territory, as the defendants did. The first defendant's registered office was the second defendant's home in Cardiff CF3, which is within the exclusive marketing territory. And that submission is recorded by the judge, paragraph 298, the judgment, where he summarises, one of the three paragraphs he summarises my submissions. Five lines down, paragraph 298, the clauses were so wide they would prevent Mr Bartlett's home from being Fredbar's registered office or from being a centre of administration, even if the business operated outside the geographical limits.
So where's that in the judgment?
298, my lord.
Oh yeah.
5 lines down. So that submission was recorded but not dealt with in the judgment.
So the point there is that even if your client was only carrying on the actual business over the other side of the Severn in England, if he was operating an office from his home in Cardiff, he was in breach of the covenant.
Yes. There's no way of severing that. Whether it just involves having that office as a post box for company's house purposes, for tax purposes, whether he undertook paperwork there, whether he was doing whatever, none of that can be severed. The words engaged, concerned, or interested in clearly extend to having a registered office, the premise. I say that that is a conclusive reason as to why the covenants go further than is reasonably required, and why the wording cannot be severed, and why they are unenforceable. My lord, I have come to the end of what I planned to say to you. May I turn behind to see if there's anything my learned junior wishes me to say, or indeed Mr Bartlett himself? I turned unnecessary. There is nothing, my lord. I'm grateful.
Right, thank you.
Lord Lady, good morning. I've just seen what the time is. I'm going to do my very best to do this very quickly and finish well before lunch if I possibly can. So I don't.
Well, you need to finish by 1 o'clock, come what may.
Oh, come what may, absolutely. No, I was indicating an intention to do better than that if I possibly can. Lord, can I deal with some of the homework that I was set over the long adjournment, and deal with convenience first? So can I go back to the passage that Lord Justice Arnold took me to, which is tab 19 in the Care Watch case?
Yeah.
It's paragraph 134, page 418. I think the point that Lord Justice Arnold started with.
I beg your pardon, could you give me the paragraph again?
Of course, 134, my lord.
Thank you.
Page number in the bundle 418. This, I think, was the paragraph that your lordship first took me to, and it was to do with the expression similar. And the point your lordship made was that while I had introduced authorities suggesting clauses with that word in it had been approved, that would appear to have been, on the face of it, not correct in light of the Convenience Code judgment.
Yeah.
Now, Lord, can I just deal with that? I haven't brought Convenience Code with me, but the clue, if I may say so, because I have looked at it very, very carefully, the clue is in the final few words of paragraph 134. The post-termination restriction, and I will make sure your lordship has this case in copy before, either before 1 o'clock or very shortly after it. The post-termination clause was found in clause 8.2.1 in convenience. That was the
Well, the point you're making is made clear in that last sentence, isn't
yes,
it?
and I have
struck down because of only because of the territorial scope, not because of the width of the rest of it.
correct. And if I could just for Lord Justice Arnold's note, if he wants it, clause 8.2.1 is in paragraph 5 of convenience. Paragraph 12 of convenience, the judge held this. 821 is plainly and admittedly reasonable in point of time. I emphasise the word time for a reason I'll come back to in a moment. The issue was the judge found it extended to the whole of the UK. It wasn't actually restricted at all, potentially worldwide. He felt that he could construe it to be constricted to the UK and not worldwide. Then he held that a UK-wide one was territorially unreasonable. So that was the decision.
Well, to be sure, and that's sufficiently clear from the last sentence, as my lord says, but the question I was trying to get to is this. Would I be right in thinking that you would accept that in assessing the reasonableness of the covenants in issue, it is material to take into account not merely their duration and territorial scope, but also their ambit? And in the present case, we are dealing with a clause that, subject to the question of severance, includes within its ambit not merely businesses competitive with Drain Doctor, but also similar to.
Lord, the next part of my response note is to say, however, having dealt with the convenience point, I still need to come back to what I'm called your underlying point, which is the point your lordship has put to me. I'm not dodging that. I did have a off-the-cuff answer to it yesterday afternoon. So let me just spend 2 minutes on telling you my overnight thoughts on it, and your lordship will make of them what you will. So the underlying point made, it seems to be regardless of the convenience decision, is whether in and of itself, similar to, is capable alone of making the clause unreasonable, simply because it's wider than competitive. I've tried to capture the point that I think your lordship's getting at, and I hope that does. And I think the answer is that I stand by what I was groping towards off the cuff yesterday, that it's fact specific. The construction exercise of any restraint would properly give a purpose of construction to similar and would not provide it with a wide construction in order to be able to knock it down. So the essence of the clause is part and parcel of policing the protection of the franchisor's goodwill, because that is in fact the beginning and the end of the concept. For a similar business to fall within the clause, it would have to be in some way a business that could damage the goodwill. That would be the reason, justification for it being there. A competitive business may be considered to be something offering precisely the same type of service. So, for example, I accepted, for the purposes of argument yesterday, that Drain Doctor was essentially an emergency service. I'm not sure that's right, actually, because it's a generic emergency and services company. But can I just accept that point for the purposes of argument? A competitive business might be narrowly construed as one which is offering precisely that type of call-out service, if that's what it was. A similar business could be one that included that sort of service. So I think I said something very similar yesterday afternoon without giving it overnight thought, and I'm venturing to submit to the court this morning that off-the-cuff view was the correct one. So I would not concede that the use of the word similar is necessarily wider than competitive, and that it must fall the wrong side of the reasonableness line, because it goes beyond the restriction of the competition to protect goodwill. I can also rely on
What about the example postulated by my lord yesterday? Plumbing as part of a new bathroom. Does that fall within the clause or not?
It would if it was competitive with the business of Drain Doctor.
That seems to me to be dodging the question. Is that caught by the clause or not?
Well, it wasn't dodging the question, because if Drain Doctor carried out that type of work, then it would be similar to and competitive with. By drawing the distinction between a structure of a business which is strictly competitive with, that is to say, a call-out service, an emergent. If that's what it is, let's say for the purpose of argument, a call-out service.
But I just don't understand that, with respect. I mean, what I had in mind was the sort of plumbing that you have if you're in a new bathroom, you have to have plumbers to plumb the new bathroom. But they in the example that's being postulated, that's the business that the defendant takes up. In one sense, that is similar to Drain Doctor's business, but it can't possibly be described as competitive, let alone as damaging their goodwill, if that's all that he does, because your clients don't do that, as I understand it.
Well, look, my point was this, and it is only this: if my clients were undertaking plumbing a new bathroom service, then it would fall properly within the clause. If they did not, then the proper construction of that clause, were there to be a dispute about it, would not permit us to rely on it.
But any business that damages the goodwill on your case is competitive with Drain Doctor.
Lord, yes,
and therefore
the reason
only businesses, the only similar businesses which damage the goodwill are businesses which are competitive.
Lord, no, because I've drawn the distinction between the structure of the business which is competitive. So the point that was put to me by Lord Justice Arnoild yesterday was this is an emergency call-out service. That is the nature of the business, if that is correct.
Well, that's the judge's finding in paragraph 3. UK's largest full-service emergency plumbing and drainage company.
But that wouldn't necessarily mean it doesn't do other things. But Lord, I'm assuming for the moment that description is factually correct, that it only does emergency call-outs. So if that were right, then competitive could well mean, and would I respectfully submit would be construed as meaning, another business which is there only to do emergency call-outs. In other words, competitive in that sense. Similar would allow us to catch, and correctly and justifiably, a wider structured business which did the emergency call-out service, but also the plumbing and new bathroom service, which the Chancellor put to me, and would be able to do so insofar as it was damaging the goodwill. So I'm respectfully submitting to you that the answer to the point you've made is one which is resolved by a fact-specific exercise when there is a dispute. In other words, it would be perfectly proper for something to fall within similar and not competitive if it had the ability to damage the goodwill.
Well,
But we
you
don't
could
have to-
you could envisage a situation where the franchisee, on termination, sets up a new business which does both emergency plumbing and the plumbing of bathrooms, and the bit that is emergency plumbing would fall foul of the covenant because that's competitive. But the bit of the business that just does plumbing and bathrooms, at the moment, it may be similar because it's all plumbing, but at the moment I can't see how it damages the goodwill of the franchisor's business at all.
Well, I'd take it the other way round, that if the franchisor's business is only emergency call out, it might be said that the full service new business of a outgoing franchisee is not competitive in the way it presents itself. It's not marketed as competitive, it's not marketed as emergency. Let's supposing it's only marketed as a I'll plumb your bathroom type service, but in fact holds itself out also to do emergency. That would require protection, I would respectfully submit, for a franchisee if in fact on that fact-specific exercise what was being undertaken was competitive. But you might need to look at the word similar in order to get there rather than the word competitive if competitive was given a narrow construction. But Lord, that's the point I seek to make. If it doesn't find favour with your lordships, I'm not going to keep repeating it. I'm not particularly stressed by it, if I may put it that way, because this one is an obvious blue pencil candidate for ground two, if I'm wrong. So can I then just mention Paniotu and Sony?
Yeah, the George Michael case.
Yeah. Now, the reason I've now, as your lordships might have imagined, read the Chitty extract, I've read Quantum, and because the passage in Quantum appeared to me, rightly or wrongly, to be derived very largely from the Paniotu case, I went to that as well. So we've read both, and it seemed to us that your lordships may well want to have a quick look at that. Now, it's a huge beast of a case, but in terms of its page numbering, but the part we're interested in is part 3, and it starts at page 316 of the report.
316.
316. And while I know your lordships have the benefit of the Quantum judgment, it just seems to me there were points worth picking up from this, so your lordships do know the derivation of the paragraphs in Quantum. So I'll just pick out some points very quickly, and I'm going to eschew submissions on them, if I may, because that will be repetitive. This is just passages. So page 316, the last paragraph, first 4 lines, refers to the equitable jurisdiction to relieve against unfair and unconscionable bargains. So his lordship in that case was drawing the distinction between equitable jurisdiction and common law jurisdiction. Common law jurisdiction is immediately opposite on the right-hand side, page 317, where with the short paragraph saying by contrast. And over the page 318, second main paragraph down, there's a reference to Schroeder, and that there were claims in the equitable jurisdiction and in the common law jurisdiction. On the next page, 329, we see a
329?
I'm so sorry, 319. I do beg your pardon.
319.
It's printed just slightly too small for my glasses. I do beg your pardon. So it's the middle paragraph where we see a recitation, and I'm not going to refer to them more than this, a recitation of familiar authority, S.A. Nordenfelt, and so on and so forth.
Yeah.
At the foot of the page, he says, I then now turn to the common law doctrine and the principles as of today governing its application. So that's where, for our purposes, the key passages start. And he then, on the next page, 320, talks about the two most recent cases being Esso and Schroeder. There's then a heading saying public policy considerations and the reference back to the rule of reason, which I think we looked at yesterday. A25 on page 321 says the rule relating to restraint of trade is bound to be a compromise, and then in the next passage, B1, the application of the doctrine itself, the court's approach to the application of the doctrine of restraint of trade to a particular contract falls into two stages, and at the very last line of that, he says the second stage is to determine whether it satisfies the Nordenfeld test. Now, the first of those stages is not, this is not the same two stages as I mentioned yesterday. The first of those stages is to decide whether the contract falls within potentially the doctrine at all. We've not asserted that this falls, we're in that first category. We haven't taken that point. So his second stage is the Nordenfeld stage. And then he goes through a very large recitation of authority, principally from Esso. So if your lordships have seen that case, could we then go through, please, to page 328?
Well, sorry, yes.
No,
you-
look,
I'm getting ahead of myself. I'm more to the point ahead of you, so please continue.
Yeah.
I'll press on, but I absolutely do not want to inhibit questions if your lordship hasn't. Page 328B3, the second stage justification. So this is familiar territory, and we've been through that. I think most of these quotes we've seen. B4, the application of the Nordenfeld test, is in the middle of page 328.
Yeah.
And B44 on the right-hand side, 329. I now turn to the first limb. By its very nature, the application of this limb test must depend on the particular facts and circumstances of each case. However, certain guidelines are, and in my judgment, do derive from Esso. So then he looks at Esso. I'm not going to get stuck in that because we've looked at that already.
Yeah.
Over the page 330, we've got the heading inequality of bargaining power.
Yeah.
So I need to bring your lordship's attention to this because that underpins where I think Lady Justice Carr was going in quantum. Since equality of bargaining power features prominently in the statement of claim in this case, it's desirable to establish what relevance inequality of bargaining power, if established as a fact, can have in the context. So that's where we start at B4.6. That leads him, I think, and I'm hoping I'm missing nothing out of relevance. I've tried not to. That leads us then to page 332, where we get to paragraph B4.6.4. So that's a relatively familiar wording. As I understand these references, they establish that while the court is in general slow to substitute its objective view as to the interests of the contracting parties for the subjective views of the parties themselves, that consideration will carry less weight and may, depending on the facts, carry no weight, where the evidence establishes the contracting parties have been negotiating on other than equal terms. Now, then, if we miss out the next paragraph, which I don't think is relevant to that point, if we then go to 4.6.6, it says, thus, inequality of bargaining power may, depending on the facts of the case, be relevant to negative and an argument to the effect that the covenantor cannot complain that the terms of the contract are capable of being worked unreasonably against him, since in entering into the contract he chose to repose a measure of confidence in the covenantee. That's not an issue that arises in this case, but it's one of the 2 points that he's made. And then he wraps those up in 4.6.7, where he says, apart from these two specific instances, there is nothing in Esso to suggest the inequality of bargaining power is, of itself, relevant to the application of the doctrine of restraint of trade. So that is, as it were, as far as that goes. Can I just make a couple of comments about that, which I hope will tie into what I've said yesterday? I'm then going to go back to look at 4.7 and standard form contracts. I'll do that separately if I may. So So the question is, he says, other than for those two instances, there is nothing in SO to suggest that inequality is of itself relevant to the application of the doctrine. Now, we accept that this allows, and I think I'd be bound to accept that in any event based on quantum alone as Court of Appeal authority. It allows the possibility of taking into account unequal bargaining power when considering his step one of Nordenfeld. But my point yesterday, and I may have overstated it, but the point I wanted to get to yesterday went to how that is to be translated into a franchise case to which it has no relevance, I respectfully submit. That's what I was trying to get across yesterday, because the parties are always going to be in that unequal position. So what we're facing here is a judgment in paragraph 305, 306, which the trial judge says that each of his reasons is self-standing. But with respect, where does that lead us with bargaining power? If the clause is unreasonable without this additional inequality point, then one doesn't need it. If it is otherwise reasonable, but inequality is going to be the determining factor, then we would run the risk in looking at this particular kind of relationship. We'd run the risk of every franchise restraint being unreasonable on that ground, if one isolates it as being the only factor. So if it's not a necessary factor, it wouldn't be needed. If it's the only factor, I would expect to submit it couldn't possibly be translated in that way into the franchise arena. So my point yesterday, and as I say, if that didn't come...
That seems to presuppose that all franchisees are alike, but they're simply not. Franchisees come in all shapes and sizes. Some are one-man bands, as here, with no experience. Other franchisees are established sizable businesses. So how is it right to treat all franchisees in exactly the same way?
Because I would be guilty here if I'm not careful of giving evidence, but it is more often than not the case that franchisees, people go into franchising without prior experience in order to be given the ability to run a business which is, as it were, oven ready. It's
Well,
ready
it seems to me
made.
that's a dangerous line to start going down, because as the judge himself says, this is an area of business, if I can put it that way, which has not yet been regulated, and I can see a very strong argument in the light of some of the submissions you've addressed to this court for saying that it ought to be regulated, and the sooner it's regulated the better. But that's not for us. I mean, the fact of the matter is, if the submission you've addressed were correct, that somehow one ignores inequality of bargaining power because it would be applicable in every case of every franchise, and therefore every franchise would be knocked down, that seems to me to be an area that's crying out for regulation.
Look,
As my lord says, you're just wrong when you say that all franchisees are in equal positions, because they're not.
Lord, I was going on to develop the point. I hadn't quite reached the end, and I'm sorry if I'd given you the impression that I had. So my point is that in franchising, inequality may be considered. I can't possibly say anything other than that in the having looked at quantum.
Well, the fact of the matter is, quantum is Court of Appeal authority.
Yeah.
For what are the relevant principles in all restraint of trade cases, and it includes inequality of bargaining power.
Lord, I've just absolutely readily acknowledged that, having now studied the case overnight. So it may be taken into account. It doesn't have to be considered. It's something the court may take into account, and I certainly cannot say otherwise. And I was hoping that I looked back at the notes of what I'd said yesterday, and I don't think I was as dogmatic as...
You were trying to persuade us just now to not to take it into account, because if we did so, it would be tantamount to saying that inequality of bargaining power was, as it were, a trump card in all franchise cases.
Lord, no, because I hadn't finished, I hadn't intended to give you that impression. So I'm not saying it shouldn't be taken into account, it couldn't possibly be taken into account, but I am saying that if it's taken into account, it should be taken into account with real care in franchising, precisely because there is the benefit bestowed on a franchisee, whether a start-up franchisee or not, of a ready-made business of which they take the benefit, with the ability then to harm the goodwill in that business by deciding at some later stage whether it's months or years later to trade without the umbrella of the franchisor. So one comes back to the simple proposition that I've already made, that it might be a factor, but it can't be more than a factor. It could never be a determining factor.
What was the ready-made business here?
Well, the ready-made business here is the brand, the name, the promotion, the marketing, the fact that it is a national company, the potential for the exploitation of national accounts, the business model, the business system.
Territory, there'd been no franchisee for years.
I think 2 years. I think 2 years. Well, the last one was 2015, but I've got the data wrong. But the answer is that the ability to trade as a national brand starts on day one, in addition to which the franchisee has the business system, the model, the manual, and everything else that goes with it, along with the franchisor's promotion and marketing, and training, and support after startup. Now, my learned friend yesterday said we should ignore the manual because it's not before the court. Of course we shouldn't ignore the manual, but it's baked into the contract. It's not before the court because its contents aren't relevant. So that's what I wanted to say about that aspect of it. Can I then go back? Is to look at B 4.7, which is standard form contracts. Now, there's a reference in 471 to Schroeder and to two types of standard form contracts. And the first is contracts which have acquired some sort of public acceptance. That's a pretty crude
Well,
word.
the first sort is just a
No, we're not in,
standard form of bill of lading or charter party.
we're not
The
in,
second is a contract of adhesion.
we're not in that category, and I'm not suggesting we are. So I'm just
Then called the contract where the exemption clause would be the great big red arrow next to it.
So then we go to the second, which hence starts with the same presumption, and this is based on what he calls the 19th century ticket cases, which is if you want to get on the train, you're stuck with the terms and conditions. So when I turned over the page, I thought there was a passage your lordships may want to see, page 334.
Yeah.
And 4.7.4, two other types of contract falling between the two extremes described by Lord Dicklop. I'm only concerned with the first of those, which is 4.7.5. Can I just ask your lordships just to read that passage to yourself, because it's quite long. If the court has read through to the end of that, there is an echo there of submissions I was making to your lordships yesterday, which does look as if that paragraph is apt to describe the franchisor's standard terms. So it was proper to bring that to your attention, lest one thought one was in the extreme categories provided by Lord Diplock. And I think we genuinely can say that we're not. We we fall, I think, somewhere between the extremes, and we can see that in 4.7.5. A footnote on the potential for some negotiation, if you'll forgive me, and let me just give you this paragraph numbers. There was some degree of negotiation in relation to this contract evident on the judgment. So, and nothing to do with the restraint, but there was some negotiation. So the paragraphs in the judgment, so let me just give them to you. 99, where Mr Bartlett considered the August projections carefully. Paragraph 100, he decided not to proceed. The claimant reviewed the projections. Paragraph 101, 2 further sets of projections were produced in September. Paragraph 104, it looks on the face of it there, the top of page 56, when you look at it, that it's that the company wasn't limited to emergency work, but I can't look behind the judgment for more than that. And then paragraph 104 little c, which refers to a side letter, which is found at paragraph 25 on page 40, which shows that the franchisor had been offered a rebate on the cost of the van. So between what was originally the deal and what was the deal on signature, there had been that form of some measure of negotiation, which I don't think is relevant for anything I was saying yesterday, but it is relevant for us to be able to say we fall within Mr Justice Jonathan Parker's 4.7.5 fairly aptly. So again, what I wanted to say was that when looking at the factors, which there is no doubt I must accept you could look at following quantum, the quantum factors derive from I think very largely from this passage, and we can see that by looking at paragraph 65 little 7 of Paniotti, where these factors are referred to as in particular within the expression. So I don't think I need to say more about it than that. I've already made my submissions about the context of franchising through the text of Paniotti as I got through it. I would like to think that I'd introduced Macaulay on the same basis, that Macaulay and Paniotti are, and I entirely accept, common law cases, not equity cases, but they are really looking at the abuse or misuse of bargaining power in the common law concept, and I'm not getting muddled up with unconscionability in equity, about exploiting songwriters with a tie during the duration of the contract. And it's a fair point, I think, to make, the lordships agree with it or not, I don't know, that the authorities noted in quantum, going to the passages that I was asked to look at overnight, do not in fact refer, so far as I can see, to any franchising cases. So I'm not trying to undermine what I've just conceded in relation to an authority of the Court of Appeal, but I am saying that I'm going to ask you to bear in mind, when looking at this for the purposes of your judgment, the features of franchising that I brought to your attention yesterday. Now, if I may move on to some general points about what Mr Grant said yesterday. I mentioned the baskets of rights acquired by the covenantor, and I've already made the point about the manual, and I hope that I've this morning given your lordship another list of the benefits bestowed, so I'll move on from that. Can I then look to categorization of this as an employer-employee case? Now, there are some passages in the judgment which your lordships may wish to remind yourself of. And I'll just give you the paragraph numbers and the short point that they go to. Paragraph 90 shows that while he was going to start as a one-person business, and not start as was the earlier proposition, as a management franchise, in other words, with somebody to assist him, it was always intended that this would become a management franchise. So your lordships will be wrongly seduced were you to think that this was a single man with a single van franchise operation. Paragraph 95 makes clear that this was a franchise which was intended to become a management franchise. Paragraph 97C refers to expenses calculated from the franchisor's average data and plainly again showed that it was planned as a management franchise. Paragraphs 177 and 179, which you'll find on page 69 of the judgment, also make clear that it was intended to be a management franchise. And page 182 on page 70 shows that he was, after he'd started, looking at the capital asset value of what he'd created, even in the short life of the franchise. Now, the judge described his go at capital asset value as I think, amateur or professional, but that's not a criticism of Mr Bartlett. But it still shows he was looking at it. Now, I do not need this material to make my commercial points, which are plain from the agreement, but they do show that the man with the van plying his trade point that's been put to you by Mr Grant, it is not in fact a fair reflection of what this was intended to be at the point at which the parties entered into the contract. And it's accepted by a beloved friend that Mr Bartlett did go into this intending it to succeed, not in thinking it was going to fail. The second point is said against us yesterday is there was no existing goodwill. That can't be right. There were national accounts to exploit, and he was granted the goodwill of a nationally named brand on day one. Next point I wanted to make was that Mr Grant spent some time taking you through the amounts that were to be invested by Mr Bartlett. And I would respectfully submit that that's irrelevant. That goes to the adequacy of consideration, the adequacy of the bargain, and that is astute.
Well, as I understand it, it was relied upon as relevant to the degree of risk that Mr Bartlett undertook entering into this agreement. Of course, as you say, and as is accepted, he was hoping for success. But do you say it's irrelevant to consider the degree of risk?
I would, because it's a commercial judgment that Mr Bartlett made for himself, having looked at August figures and decided he didn't want to proceed, having looked at revised figures in September and having decided that he did want to proceed, and having made an election, the way he wished to proceed was to start as a man with a van without the second party to help him, and would then upgrade to a management structure subsequently, but quite quickly subsequently. So these were commercial decisions made by him. The degree of risk he was taking on falls, I would respectfully submit, into what I would call the freedom to trade part of this bargain. So every authority we've looked at starts with the proposition that what we're dealing with in restraint of trade public policy is a conflict between the public policy for people to enter bargains freely and the public policy that certain types of activity should not be restrained more than is reasonably. And therefore what we're looking at here is whether the restraint is reasonable. The reasonableness of the restraint is not dictated by how much he commercially chose to invest. The reasonableness of the restraint is going to be dictated and should be dictated by the point that was debated between the bench and Mr Grant this morning about the need to give an incoming franchisee a clear run in order to protect the goodwill and business of the franchisor. That's the key question. And therefore, while I don't in any way, shape or form say this in order to not accept the quantum analysis of what the highline principles are, there is a feeling in which one can see that the application of these principles is going to be different, and in fact has been different, depending on where they're applied. So though it might be applied with certain conventions in employment, they might be implied with certain other conventions in the entertainment case, which is really, as I say, more about exploiting, misusing the bargaining power in order to tie somebody.
As you say, I mean, that's the key, isn't it? Because if it were true, as you submitted yesterday, that inequality of bargaining power was irrelevant, then you could understand your proposition you advance now that the degree of risk to the franchisee is equally irrelevant. But once you accept that inequality of bargaining power is relevant, that demonstrates why risk is relevant. Because the reason why a more intense focus is required is precisely because these two things go hand in hand. Where there is inequality of bargaining power, and the paradigm case is the employment situation, there is a correspondingly greater degree of risk to the disadvantaged party.
Well, Lord, in my submission, that doesn't apply here, because the amount of money that Mr Bartlett was prepared to invest was not a function of any inequality of bargaining power. It was a function of his analysis, bearing in mind all the accounts and projections that were given to him with independent assessment, and having discussed it with an at-West business advisor to see if he could obtain a loan against it. That's got nothing to do with inequality of bargaining power. We know there was some negotiation leading to the side letter, and I've just walked you through that. So the difficulty I would respectfully submit the court would have is to say that one is dictated by the other. It was for him to make his own assessment as to how he could make what he wanted to be an independent business work. The mechanisms...
To be sure, I quite understand the point you're making is it was his commercial decision to enter into this agreement, and it was for him to weigh up what degree of risk commercially he found tolerable. That point I entirely accept. But the question then is, given that the restrictive covenants are part of a 120-page standard form agreement, which, subject to some bit of negotiations around the edges, are presented to him on a take it or leave it basis, is the restriction that contained in the covenants we're concerned with reasonable?
Well, I dealt with that. The answer to that is it's reasonable if it's necessary to protect the interests of the franchisor. On what basis would it become unreasonable, I would forensically put, if this draft contract was provided to him long in advance with the opportunity not only to read it, but to take advice on it. And there is no suggestion that there was any exploitation or misuse of his inequality. And that's why it's different from Macaulay. That's why it's different from Paniotti.
Oh, sorry. In the Macaulay case, he could have taken legal advice. He didn't. He was young and naive, but nevertheless, he could have taken legal advice. Why is the ability to take legal advice a panacea?
Well, because there's nothing as a panacea, Lord. I'm not saying there's a single get out of jail issue here. I do accept. Look, I have to accept that and I hope I've done that candidly this morning, having got my head around quantum overnight. That your lordships are going to want to look at a balancing act. There's nothing definitive about any of these points, which is in a sense the sadness about the debate of categorization, which I'm going to come back to in a minute, because in one sense the categorization debate leads nowhere. If we want to look at the substance of it.
Exactly, but you see, as soon as you say it's a balancing act, why should we interfere with the way in which the judge has balanced it? Because there's legions of authorities that establish that this court does not interfere with evaluative assessments by judges in all kinds of contexts. So if what the judge was tasked with was a balancing act, to use your expression, why should we interfere?
Lord, because a balancing act has limits. That the only part of A to D I've accepted is inequality, because I must accept it in the light of quantum. But paragraph 305 has within it a whole bunch of other things which are a balancing act. And what I said yesterday, please don't misunderstand when I use balance today. what I said yesterday is this is not an exercise under ACTA of considering whether there is or is not an unfair contract term embedded in this franchise agreement. So please don't misunderstand what I'm saying when we're saying you're good at balancing act, because that is the exercise that, with respect, the judge has done, and that is the exercise in which he has manifestly fallen into error. Because if you like, more or less everything in A to D falls into the category of matters which I respectfully submit are not part of this balancing exercise. The only one I'm conceding today, I'm not so sure I was quite as dogmatic as I may have been taken to be yesterday, because I was looking at this not as a matter of headline legal principle, but as it applied to franchising. The only one that I'm dealing with this morning is inequality of bargaining power. And nothing else I've said yesterday, in my respectful submission, stands to be qualified. Now, well, I'm either right about that or I'm wrong, and I've got a feeling that so far I haven't persuaded your lordships that I might be right, but I'm still hoping that I can achieve that. But what I think would be, if I may respectfully say, wrong if one would just simply say we have to leave this to the judge who evaluated everything. The question is, what did he evaluate and on what principles? And I do understand, because the words of the judgment say he read chips away, looked at the principles, and then purported to apply them. But what he's included in the application manifestly falls out with the principles. So that is what I want to say about that. May I move on now to categorization as a revisitation of it? I've already mentioned it briefly, but learned friend did come back to it this morning. So what he said was that the failure to negotiate, the inequality of bargaining power was the reason for the differentiation between vendor-purchaser at the one hand and master-servant on the other. I think with respect he's wrong about that. The authority I took you to yesterday, I think at least two of them, said that the reason for the distinction was because no person should be unable to ply their trade as an employee, and every employer should accept competition. That was the starting point. I've got to be careful about what I can recall, but I'm not sure there's any authority before this court which supports the proposition that the distinction between vendor-purchaser and master-servant, insofar as that is a helpful, relevant distinction, has ever been driven by the inequality of bargaining power. And neither could it be, because, in fact, there are some very rich employees and some reasonably poor purchasers of businesses. So I don't see logically how that would be so, but there's no authority before this court to support it. The second point, he took you to law by design, which suggests that the characterization should be departed from, and it's only a starting point and it's all a question of substance. I don't necessarily disagree with that. In fact, insofar as we rely upon Dynarod itself has only ever said, Justice Duesberger, that it doesn't fit comfortably within either one, but it's nearer one than the other. That is quintessentially an assessment of substance rather than something dictated by characterization. And we don't seek beyond that. The next point that was put was the difference between points of entry and points of exit. The correct approach, we would say, is that franchising is a commercial agreement in which the franchisee wishes to have the benefit of the franchisor's goodwill in business. And while the entry/exit point is factually correct, as Mr. Grant explained it, it's just not a relevant point. And I would respectfully submit that it's wrong to confuse or run the risk of confusing the characterization argument with the bargaining power argument. Then I wanted to just revisit, because I may have misheard what Mr Grant said in his exchange with my Lord Justice Arnold. But I think he took you through Colquitt, Diderot, Chips Away, Care Watch and Countrywide Signs in order to demonstrate the amount of time that had passed where the franchisee had been engaged in that capacity.
Yeah.
I'd hoped I'd understood that, and I had. And with respect, I entirely understand, if I may say so, without being pertinent, Lord Justice Arnold's suggestion that there are facts which can colour one's approach to a legal decision, of course. But it's crystal clear that how long a party remains under the yoke of an apparently unlawful restraint or unenforceable restraint of trade laws is absolutely irrelevant to whether it's enforceable or not.
Well, can I suggest, I mean, as a matter of legal principle, I think you're absolutely correct. But the relevance of it seems to me in the present case is it goes to the question of the sliding scale. Because you posit the question, well, why has nobody suggested the sliding scale before? And the answer is because the facts didn't support the argument. So if you've got a case where the franchisee has been in place for many years, then the argument based on the sliding scale looks unattractive. Whereas this case is factually different because you're concerned with someone who has been terminated very early on in the 10-year period. And given the factual substratum, that actually throws into relief an argument which was actually legally always available.
That I could quite understand that if we're looking at sliding scale. But if we're not looking at sliding scale, I'm going to come on to address you on sliding scale in a moment, because I think that the answer's very, very clear. But the point here is that the length of time someone has been there is simply not relevant to the question that your lordships have to answer and the trial judge had to answer. Because that's got to look at this arrangement on the day that it was entered into, and that we're all agreed about that, and the cases are all utterly consistent. And I then wanted to bolt on to the bottom of that a reference to the exchange law that you had with Mr Grant about consistency. In other words, how the consistency point. And it's a fair point to make, and forgive me if I'm going to make it, but it is a very fair point to make, that there were perhaps hundreds of lawyers drafting agreements for hundreds of franchisors in relation to thousands of franchisees. And there is a strong presumption, in my respectful submission, in favour of consistency. So when this is the, in a sense, leading on to the slightly separate debate as to whether you're looking at this in its commercial context or whether you're looking at only this one agreement between these two people. And of course, the law we've seen from Paniati this morning, which we looked at yesterday, says that you do start in its commercial context and look at the individual. You do both. And you can't ignore, I respectfully submit, the structure in which these agreements exist. Then on to consent clauses. I was looking back at from the notes that I've been given of what I did say yesterday, and my error, I think, may have been to address the first line of E in a compendium way rather than breaking it up, because the way in which the judge has dealt with it is that without a clause saying that consent is not to be unreasonably withheld, that even a consent clause would be unreasonable. And I was more motivated by that yesterday than I was the first part of what you said in that sentence. And none of the clauses that your lordship's been taken to today have the unreasonable withholding part. So one might end up in a situation where, in the absence of an unreasonable withholding clause, one was debating the potentiality for implied terms, or was debating the potentiality for it being a contractual discretion, in relation to which there would be similar but different factors in play. But on the face of everything that your lordships have seen today, in order to put what I said yesterday into context, none of them had unreasonable withholding mechanisms. And it was that part of the judgment that I was attempting to address. Burden of proof is next. That is not in dispute, and I took you to that law, I think, yesterday. So the burden's on us. And insofar as there could be a third issue in the case, overriding public policy, as it were, which we looked at, that burden would be on Mr Grant, and he conceded yesterday that he's not advanced that. Then, in relation to evidence, he took a point against me that there was no evidence in support of either the interest to be protected or the reasonableness. I don't want to go over that, but I did at some speed yesterday give your lordships paragraph references to the two witness statements of Mr Jean. You were taken to one of them today, paragraph 47. I also gave you paragraphs 50 to 61 yesterday in the supplemental bundle, tab 8, which provides some of the factual substrata which then underpins paragraph 47 of tab 11. But we did produce evidence in relation to it, and sufficient evidence. And if I may say so, I did make the point yesterday that this was about giving the incoming franchisee a clear run, so the franchisor an ability to recruit, install, train, and give that franchisee a clear run on a level playing field. And that then brings us to sliding scale. Now, I think there's a simple answer to sliding scale, which the judges got wrong, and is no answer in this case. If we are correct about the issue being that we should have a restraint which is sufficient to give the incoming franchisee a clear run, then on the evidence, a sliding scale does not work. Because a sliding scale assumes a restriction, but for a lower, shorter period. If we have satisfied the court on the evidence, and should have satisfied the judge on the evidence, that a year was reasonable to give the franchisor an opportunity to identify, recruit, train, install, and then for that person so installed to have a fair and clear run. If we've correctly gone over the threshold that 12 months is not unreasonable for that, or is reasonable for it, then a shorter period would be wholly ineffective and would defeat the entire purpose of the clause. So, that if we're right about it, Mr Grant may be correct in saying that a longer period may be justified subsequently because that feels right, and he made that concession this morning. If you get closer to 10 years, maybe more than 12 months is needed. The difficulty with that is this. What we're saying is that we need the 12 months in order properly to identify, recruit, sign up, train, install, and for that person to have a run. That doesn't get any longer after 7 years or 8 years. I can see an argument that the person might want a longer clear run if the older franchisee had been there for such a long time. But all that suggests is a sliding scale should start at 12 months and get longer possibly. And then I'd be standing here trying to justify a sliding scale clause which started at 12 and ended up at 36. So, but my starting point here is the whole sliding scale issue feels seductive because it feels as if it might be right on a human scale, but it defies the logic of where we have to start. We're not starting because we want to prevent competition. We're starting because we have a legitimate interest to give the incoming franchisee a clear run, and that takes a year. Well, if it takes a year at the beginning, it takes a year at the end. Having a shorter period at the beginning entirely defeats the purpose of it, and therefore all this amounts to is, my learned friends, starting, if I may say so, a somewhat academic debate, a moot debate, as to whether this clause could have been longer at the end of the period if we'd introduced the sliding scale. It doesn't affect whether it could have been shorter at the beginning. My next point, very briefly, is this. We've conceded there are no trade secrets properly construed. I've never said otherwise. But of course, there is evidence, and you'll see that from Mr. John's paragraphs 50 to 61 of the first of the two witness statements I've just mentioned, that there is confidential information imparted. I'm not drawing any assistance from that for the moment. It's just as a point of principle. I just want it to be known that there is evidence for confidential information. We make no claim for trade secrets. Another point, very quickly, I'll just pick up a few random points, if I may, that Mr. Grant made this morning, was that that an emergency plumbing business will have no repeat business, and anyone that rings them up will be purely by happenstance. I have to say, I find that really rather surprising, because there are brand names which are used in every walk of life and achieve prominence. There's a well-known firm that will allow you to press your telephone and a taxi turns up at your door to take you somewhere. That's a brand name. There are lots of other people who will answer the phone and send you a personal taxi. So I don't think that's a relevant point. I then want to move on to reciprocity. And it is an irrelevant point, this reciprocity point. It's irrelevant because the franchise network is owned by the franchisor. The franchisor must be entitled to continue that network. There might well be a claim in damages brought against the franchisor if the franchisor was in repudiatory breach and caused damage to the franchisee. But the entire structure of the network, which I went through yesterday, which affects not only the franchisor, but also affects other franchisees, is dependent upon having franchisees in place, not competitors in place. Now, Lord, lest it be said against me that that is incorrect as a submission because it prays in aid in relation to this contract the interests of other franchisees under different contracts. My answer to that is as follows. Yes, it does. But this franchisee was a franchisee who would be benefiting from the equivalent point in everyone else's franchise agreements. I made the point yesterday that franchisees to this extent are interdependent. And they're interdependent upon the franchisor keeping control of the network, policing standards in the network, and ensuring that everybody has a virtuous circle of benefit from the network. So when Mr. Bartlett was a member of that network, he had that benefit. He can't take the benefit of it as a franchisee surrounded by other controlled franchisees and say, well, in my particular contract, it's essential that if you're in repudiatory breach, you need then to disadvantage everyone else around you, around me, or people who were around me, by allowing me to trade for a year, and you can't have any form of franchisee in situ. Then very quickly, if I beat 1 o'clock, my lord, it won't be by much, but I will, I promise, wind up very shortly. Severance. The issue about severance is a pretty short one, I think. We both agree that severance, blue pencil severance, is not relevant between sub 1 and sub 2 because they're independent. So that's not a blue pencil issue. If there is concern in your lordship's minds about engaged, concerned, or interested in, then you can take a blue pencil test, and you can take out engaged. You can take out concerned if you want. But interested, engaged could well be construed by the court as a clause which would prevent what I'm going to call pure employment. In other words, no contact with customer. The point that I think Lord Justice Arnold was putting to me yesterday. If that was the concern that you were to have, then in my submission, you could resolve that concern by removing the word engaged, because that person would then not be engaged. But interested in, it would not be an appropriate expression to describe pure employment. So the blue pencil test does work there if you're against me on the ground one points.
Why not? If somebody's employed by a plumbing business, they're interested in the business, aren't they? They're certainly concerned with it.
They're just engaged by it. I venture to submit that no one in those circumstances would say that they have an interest in that business beyond the terms of their engagement. Now then I need to deal
The problem
very...
you've got is that the expression engaged, concerned or interested in is really a catch-all expression that's used in hundreds of different types of franchise agreements.
It is.
No doubt for good reason.
Well, Lord, may I say...
to cover all the eventualities.
First of all, they are there to cover eventualities, and anything I'm saying about blue pencil does not detract from what I said yesterday on principle.
Understand. We're simply on the issue of blue pencil here,
This is,
whether by blue penciling engaged you really achieve anything at all.
Oh, look, I'm going to hope to win on ground one that I can justify this entire clause on a policing basis anyway.
No, I understand all of that, Mr. Jones, but at the moment we're on ground two.
So
what I was putting to you is that by removing engaged, I'm not convinced you actually achieve anything at all in terms of narrowing the scope of the provision.
I'm not going to suggest that if you're not convinced yet, you'll be convinced if I say the same thing second time. So I'm not going to. So now I'm going to deal with the second RN point, which came right at the end, which was the business-based point, which I think, if I may say, looked as if it gained some traction with your lordships. It seems to be, if I may say so, an absolutely thoroughly bad point. Can I just invite you to have a look at clause 18, page 88 in the bundle. That's where it is in the judgment.
Yeah.
And surely what this means is I'm just going to pick up the words competitive with the drain doctor business within the EMT. So what one would be interested in is somebody being competitive with the drain doctor business within the EMT. So if somebody had, let me just take a simple example, a registered office in their front room, or a lock-up garage with no marketing attached to it, and they drove 40 miles or 30 miles or whatever the radius would have to be to go and work somewhere else, they would simply not be competitive within the EMT. As a simple construction argument to that, it's an Aunt Sally that's been put up. I would
What
respect.
about similar to? I mean, if you blue pencil similar to, I can understand the argument. But if similar to remains, why is that? Why does that not catch it?
No, because it would still, for precisely the same reason, not be caught at all. So you won't be engaged by a business similar to Drain Doctor within the EMT. If you're engaged to work 40 miles away, you wouldn't be. The only point here, this is a very narrow point, that it's that Mr Bartlett would be prevented from having his own business space within the EMT. And I've just suggested to your lordships by way of submission that that's a bad point because it misconstrues the clause. It sets up a construction of the clause in order to have an Aunt Sally to knock down. It's not the proper construction of the clause. John, I did promise you some saving of time. I've reached the end of my notes this morning. I therefore have saved you 10 minutes. But unless your lordship have any further questions of me, unless anyone's going to tell me that I've missed something major, will you forgive me just for a moment?
No, thank you, Mr. Jones.
No, thank
technically, you've got a right to say something if you want to about the George Michael case.
That was exactly what I was going to say. Technically I do, but I don't.
Good. Thank you very much. I think we can do it all for ourselves. We've got quantum as well. Right. Well, thank you both very much for your extremely helpful submissions. Inevitably, the court will reserve judgment. And make no promises as to when you will get a draft. We'll try and make it as quickly as possible. When you get the draft, please only typographical and similar corrections. Do not seek to reopen arguments, and if you can agree an order prior to hand down, that will be helpful. If you can't, we'll deal with any issues that arise on paper. Of course, thank you all very much. Thank you very much to those who've assisted you on both sides.
Before the court closes, may I just ask if your lordships do want a copy of convenience? I won't trouble you with it if you don't, but I will if you would like it.
No, I don't think so. I think it's perfectly apparent the basis on